Case of, okay, I have to say, got it. Calling the case of Marks versus Sonny's Rooftop Bar. So can all the people show up and give their appearances? So I'll take appearances, starting with the plaintiff.
I'm sorry, Your Honor. Could you hear me okay?
I did not hear anything until, could you hear me okay?
Okay, my
I heard
call
that.
just cut out. But Your Honor,
Sure.
my name is Jaden Wittere. I will be representing the plaintiff, Ethel Marks, in this case, along with my second chair, Larissa Laura.
Welcome.
From the defense, Your Honor.
Yep.
My name is Sammy Morris-Beber. I will be representing the defense, Sonny's Rooftop Bar, along with my second chair, Maya Musselman.
Good
Welcome.
morning, Your Honor.
All right. Are there any preliminary matters to attend to before we hear opening statements?
Yes, Your Honor. There are a few preliminary matters from the plaintiff, if we may proceed with those.
Go ahead. Go ahead.
Your Honor, first, we would like to bring to the court's attention that Exhibits 1, 22, and 23 have been pre-admitted for today's trial.
All right. 1, 22, and 23.
Yes, Your Honor. And next, we would like to bring the court's attention to Rule 615, which states that all witnesses are constructively sequestered, barring party representatives.
That's my favorite rule.
And Your Honor, with that, we would also like to acknowledge that the plaintiff does not have a party representative in court today.
Very good.
And Your Honor, finally, we would just like to ask your preference on when we display exhibits for the court. Would you like us to ask permission, or should we just display the exhibits and signify that we're going to do so?
Go ahead and display them.
Thank you, Your Honor. Now, with that, the plaintiff has no more housekeeping matters.
All right. Anything additional from the defense?
Yes, Your Honor. First of all, as we are competing on Zoom, there may be some technical difficulties. So please let me know if you at any time can't see or hear me. And I would like to inform the court that I will be using testimony from Stevie Rieger, who is an unavailable declarant in today's case. So I'll be reading his testimony into the record.
Very good. Anything
And
else?
that's all from the defense, Your Honor.
All right. In that case, let's hear opening statements, starting with plaintiff.
And Your Honor, just before I start, once again, can you see and hear me okay?
You know, your background is kind of blurred, but I can see you.
Would you prefer if I unblurred my background, Your Honor?
It's totally up to you. You've done this before, I'm sure.
Yes, Your Honor. May I begin, Your Honor?
Whenever you're ready.
They served, they observed, and they couldn't care less. The defendant watched on the night of March 24th, 2019, as they slowly drove a 19-year-old girl to her death. Jessica Marks was a minor, a 19-year-old minor who served drink after drink after drink by Sonny's Rooftop Bar. And those drinks, as you'll hear in this trial, pushed Jessica Marks closer and closer and closer to the bottom of a ravine off the Pacific coast of California. Someone's responsible. Who? The defendant, Sonny's Rooftop Bar. But members of the jury might be wondering, how exactly did a 19-year-old girl get to the bottom of a ravine? Well, the answer's simple. A hard seltzer, then another and another, a pint of beer, an entire shot, and 6 glasses of wine. Now, you're not mistaken, because Jessica Marks drank all of that only at Sonny's Rooftop Bar. A 110-pound, 5-foot, 19-year-old girl drank and drank and drank, and she was served until she was tripping down flights of stairs, until she was yelling incomprehensible sentences, until the bar manager questioned if she was planning on driving and if she needed to be cut off. Sonny's Rooftop Bar, as you'll hear in this trial, had countless signs that screamed that 1, Jessica Marks was a minor, that 2, she was obviously intoxicated, and 3, they knew that she was a minor, she was obviously intoxicated, and they continued to serve her on March 24th. Now, as the plaintiff, members of the jury will be the first party to tell you that Jessica Marks' actions, they could be labeled as irresponsible. Unfortunately, none of that matters now. It's too late to ponder over what Jessica Marks did wrong, what she could have done differently, and why we're here. Because who we do have today are the ones responsible. Sonny's Rooftop Bar. Now, you see how the defendant's responsible is because they looked at Jessica Marks and her bloodshot eyes with her red cheeks and poured another drink. They poured another drink and they poured another drink, and they kept pouring drinks until she landed in the bottom of a ravine. Members of the jury, if my word isn't enough for it, you'll hear the testimony from Morgan Levin, Jessica Marks' best friend, and the sole person accompanying her to Sonny's Rooftop Bar. Ms. Levin won't portray Jessica as a saint, and she'll just tell you the truth about what happened that night. She won't let bias influence her testimony. She'll deliver you the facts. Now, members of the jury, just to look at the law part of this a little bit more, according to California's Business and Professional Code, if you overserve someone in your establishment, you're liable for any injuries that happen to them. And in addition to that, the Dram Shop Act tells us that if a customer at any bar is intoxicated by their product, it's their duty to stop serving. It's not their choice, it's their duty to stop serving. And if they don't, they can be held liable in a civil proceeding. And what we're here for today is a civil proceeding. Now, we will prove our case through preponderance of the evidence because we bear the burden of proof in this case. And when we do, we ask at the end of the trial, you deliver a verdict in favor of the plaintiff. Thank you.
Thank you, counsel. I'll hear from the defense.
Don't drink and drive. We've all heard this. We hear it when we turn on the TV, from our parents before we're ever allowed behind the wheel of a car. Don't drink and drive. But that's exactly what Jessica Marks did on March 24th, 2019. She drank, she drove, and tragically, her car went off the road. There is no doubt about the impact of Ms. Marks's death on her friends, on her mother. So before I dive into the elements of today's case, I would like to express my sympathies to the Marks family for their loss. But at the same time, it is also my duty to show that Sonny's Rooftop Bar is not liable for Ms. Marks's accident. We just heard the plaintiff walk through their burden of proof, that they must prove Ms. Marks was obviously intoxicated when served drinks, and that Sonny's Rooftop Bar furnishing that alcohol was a proximate or substantial factor in Ms. Marks's accident. So the defense will offer evidence that Sonny Mehta never saw Ms. Marks obviously intoxicated. In fact, you will hear two differing accounts of that night. You will hear from Morgan Levin and one from Sonny Mehta. But the defense will offer a third account, another bar patron who was there, who saw Ms. Marks's behavior and who saw she was not obviously intoxicated. But even regardless of how Ms. Marks appeared, you'll hear that what a best friend of 6 years sees over the course of 3 hours is very different from what a working bar owner sees, from someone who sees Ms. Marks for 30-second intervals. And the plaintiff will fail to meet their burden to prove that Sonny's is liable. But in addition to addressing the cause of action the plaintiff has brought, I, as the defense, have offered an affirmative defense, one that argues Jessica Marks is at fault for her accident. And to show this, I will present evidence of Ms. Marks's actions that week leading up to that night. Because that night, members of the jury, you will hear Ms. Marks was drinking before she ever even got to the bar. You will hear she had a glass or two of wine at her Airbnb before she decided to drive to Sunny's. And you will hear that she decided to order drink after drink after drink, knowing she'd have to drive herself home. You will hear that she walked out of that bar. She refused an offer for a cab from her friend. She decided to walk over to that car, to put her key in the ignition, to start it, and to leave. You will hear that it was her choice to drink, and it was her choice to drive. And it's a sad reminder, don't drink and drive. And at the end of today's case, I will ask that you find Sunny's Rooftop Bar not liable for Jessica Marks's car accident. Thank you.
Okay, thank you, counsel. Are we ready to hear our first witness?
Yes, Your Honor. To begin, the plaintiff would like to start by calling Morgan Levin to the stand. May we proceed, Your Honor?
Mhm.
Please state your name for the record.
Hi, everyone. My name's Morgan Levin.
And Ms. Levin, is it fine if I call you Morgan?
Yeah, that's fine. I'd prefer that anyway.
Morgan, I'd just like to start off by talking about the relationship between you and Jessica Marks. When did you and Jessica Marks meet?
Jess, I miss her so much. We met in middle school. We had the same birthday. We met in middle school. Yeah.
And how long did you guys remain friends for?
I mean, we're still friends now. Jess is always going to be my best friend.
I'm sorry to hear about your loss, Morgan. Can you just tell the jury about the last time you saw Jessica Marks?
The last time I saw her, it was it was March 24th, 2019. She'd been visiting me from Philly.
And what did you guys plan to do on March 24th, 2019?
Well, Jess was going home the next day, so we just wanted to do something before she left, and we went to Sunny's Rooftop Bar.
Why exactly did you choose to go to Sunny's Rooftop Bar?
Well, we chose to go there because Sunny's had a reputation around campus for serving without harming people.
So did
Objection,
you
Your
end
Honor, relevance.
if I may be heard, Your Honor?
No, this is preliminary. I'm going to overrule that.
Yes, Your Honor.
Now, did you end up getting served at Sunny's Rooftop Bar?
Yeah, we got served by Sunny Meta.
Now, when you're at Sunny's Rooftop Bar, before that point, what was Jessica's demeanor like?
Well, before we went to Sunny's, she had had a glass of wine. So by the time we got there, Jess looked a bit tipsy.
Now, what about her demeanor when she was at Sunny's Rooftop Bar?
As the night went on, Jess looked drunker and drunker, to me at least.
And what were some of the signs that she showed that she was drunk to you?
Well, over the course of the night, Jess got louder, and what she was saying didn't really make sense. And one time, she even stumbled into Sunny Meadow on the stairs when we were going to the bathroom.
Now, with these symptoms, how many times was she served?
I mean, Jess had more drinks than I think she should have that night. But we saw the bartender, Sunny, around 8 or 10 times.
And did you document the times that she was served?
Yeah, through pictures from my Yelp account.
Now, Your Honor, at this time, my second chair will be displaying Exhibit 14 for the court. Now, Morgan, can you just tell the jury which of these drinks belong to Jessica?
Yeah, this is the picture that I remember taking. And All of the drinks on the table belonged to Jess except for the wine. That was mine.
Thank you, Morgan. Now, I'd just like to get into a little bit more about Jessica's demeanor. Did you witness her demeanor before you got to the bar and when you're at the bar?
Yes, I was with her the entire night.
And did you document these just like you documented your drinks?
Yeah, Jess recorded a video of herself that she posted to Instagram at her Airbnb. And
I'm sorry to interrupt. I may not have understood the question at the beginning and the preliminaries about the use of exhibits. So it's fine to display it to the court and outside the presence of, jurors or whatever, but are you planning to move its submission?
Yes, Your Honor.
Okay, go ahead. I didn't mean to interrupt. Sorry, go ahead.
My apologies, Your Honor. And Your Honor, we would like to bring up Exhibit 14 one more time, if my second term may display this exhibit. And Your Honor, at this time, we would move to enter Exhibit 14 into evidence as well.
Any objection?
No objections, Your Honor.
All right, then Exhibit 14 is admitted into evidence.
And Morgan, you just stated that you took videos of Jessica at the Airbnb and at the bar. So at this time, I'll be displaying Exhibit 6 and 10 for the court. And based on your knowledge, have these videos been altered in any way just off the front appearance of them?
No, this is how I remember the videos from my camera roll and from Jess's Instagram account.
Your Honor, at this time, I would like to move to enter Exhibit 6 and Exhibit 10 into evidence.
Any objection to 6?
No objections, Your Honor.
All right, any objection to Exhibit 10?
No objections, Your Honor.
All right, so Exhibit 6 and 10 are admitted into evidence.
Now, Your Honor, this time I would like the record to reflect that I'm now playing Exhibit 6 for the court.
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. Go hard or go home. Not ready to go home.
Now, Your Honor, at this time, I would like the record to reflect that I'm playing Exhibit 10 for the court.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a silly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad inspired me. Okay, well, go big or go home.
Now, Morgan, can you please tell the jury what differences you can make in Jessica's demeanor from both of these videos?
The first video, that's the Jess that I know and that I love, and I miss her so much. But in the other video, I was a little concerned about Jess. Throughout the night, I kept asking her if she was okay. In the video, she isn't really making sense, and her speech is slurred.
Now, Morgan, I'm sorry to talk about this again, but I'm just going to go a little more into detail of Jessica that night. After you observed Jessica's behavior that night, did you witness anyone else observing her behavior?
Yeah, the bartender, Sonny, was on the roof the entire night, and he never did anything about Jess's behavior.
Did he say anything about Jess's behavior?
Yeah, like I said, when we were on the stairs, Jess bumped into him, and he said that we might need to cut this one off to the other bartender. Then he made another joke later on in the night. He said, "I hope this one's not driving."
Now, after making both of these comments, were you guys finally cut off from drinking that night?
No, we were never cut off. Um, we left when they were calling last call for alcohol, but that's the only reason.
Now, after that, did anything else happen? Did you guys do anything else?
Yeah, we left at around 11:45 after I paid my tab, and I tried to get Jess to get an Uber with me, but she wouldn't come.
Now, Morgan, if Jess didn't get an Uber with you, how is she planning on getting home?
She was going to drive her rental car that she got back to her Airbnb. I just told her she could come back and get it tomorrow, but she was leaving the next day, so I guess she just thought it was urgent to take it back.
And Morgan, I'm very sorry to go deeper into this, but did Jessica get home that night?
No, I was in my Uber. We were right behind her. I'm sorry.
It's all right, Morgan. Now I'm just gonna wrap this up here for you. I'm sorry, Morgan.
She crashed less than 1,000 feet away from the bar that night, and I saw it.
Now, when you guys are ready to leave the bar and Jessica was getting into her car, what did Sunny Meadow or anyone else at Sunny's Rooftop Bar do to ensure that she was not intoxicated?
Absolutely nothing.
Your Honor, I have no further questions at this time.
All right, cross-examination.
Yes, Your Honor. Good morning, Ms. Levin.
Good morning.
And I know this must be hard for you, so please let me know at any moment if you need to take a minute and to take a breath.
Okay, thank you.
You've known Jessica Marks for a long time, haven't you?
Yeah, I knew Jess since middle school.
That's right, you've known her since 2013, right?
Yeah.
But after Ms. Marks's car accident, her mother, Ethel Marks, threatened to sue you, didn't she?
Yeah, emotions were really high after Jess died.
But she didn't end up suing you, did she?
No, I never got sued.
Instead, you're here as a witness for the plaintiff, aren't you?
Yes, they asked me would I testify against the bar, and I agreed.
You made a deposition, didn't you?
Yes.
But before making that deposition, you spent 2 to 3 hours with the plaintiff's attorneys?
Yes, we spoke the day before I gave my deposition.
All right, let's talk more about the week of March 18th, 2019. That was the week Jessica Marks came to visit you, wasn't it?
Yes.
When she came to visit you, she brought 2 fake IDs with her, didn't she?
Yeah, she called it our early 21st birthday present.
She brought one for herself, right?
Yes.
And she brought one for you?
Yeah.
And then the 2 of you went to 8 different bars and restaurants, right?
Yeah, we went bar hopping quite a bit that week.
Ms. Marks had also rented a car for that week, hadn't she?
Yeah, I think I mentioned it earlier.
She used that car to drive to those restaurants?
Most of them, some nights we just walked around, some nights we drove, depended.
Ms. Levin, there was one night when she didn't drive, is that right?
Well, yeah, that was a night where we walked around downtown.
But the rest of the nights she drove to and from those places.
Yeah.
And she drove the night of March 24th, didn't she?
Unfortunately, yes, she did.
So let's talk a little bit more about March 24th. You first saw Ms. Marks at around 6 o'clock, right?
Yeah, she had picked me up from my dorm.
The two of you went to her Airbnb?
Yes, we went there for a little while before we left.
And you saw Miss Marks drink 1 glass of wine,
Yeah,
maybe 2.
maybe. I can't quite remember. It was either 1 or 2.
I'd like the record to reflect that I'm screen sharing what has been marked as Exhibit 5. Miss Levin, this is a copy of a picture Miss Marks posted to Instagram, right?
It's not on the screen, but I remember the picture.
Yes, I apologize for the technical difficulties we're having here.
Yeah, that's the picture I remember from her Instagram account.
It's fair and accurate to the best of your knowledge.
Yes.
Your Honor, at this time, we offer Exhibit 5 into evidence.
Any objection?
Yes, Your Honor, as to hearsay.
All right, you want to explain that?
Yes, Your Honor, this is an out-of-court statement, seeing that it is an Instagram post that is being offered for the truth of the matter today.
And your response, counsel?
Yes, Your Honor. I believe Mr. Wittere is referring to the statements made below the image, such as the start to a good night. We're not offering these for the truth of the matter asserted that a bottle of wine is the start to a good night, but to show Miss Marks's intent for that night.
If I may respond to that, Your Honor.
You may.
Your Honor, this hearsay objection is not to the caption, the hashtags, nor the comments. This is specifically to the picture and the Instagram post in itself.
Okay, well, seeing as how we've admitted a bunch of pictures as part of the plaintiff's case, we're going to admit this one too. Exhibit 5 is admitted evidence and the objection is overruled.
Yes, Your Honor. And Your Honor, at this time, may we publish this image for the jury?
You may.
Miss Levin, this picture depicts 2 empty wine bottles, right?
Well, one of them were half full. That's the one me and Jess drank from that night. But the one on the left, that one was empty.
Ms. Marks has also tagged the picture or has captioned the picture with the start to a good night.
Yeah, we were planning on going out that night. I imagine that's what she was referring to.
She tagged it with hashtag go big or go home
Yes.
and hashtag spring break.
Yeah, that's what she was there for.
Ms. Marks then drove the 2 of you to Sunny's bar, right?
Yes.
And she ordered drinks while at the bar?
Yeah, we both did. We were there from about 9 to 11:40.
That's right. I'd like to talk about the end of the night. You and Miss Marks left at around 11:30, as you stated.
Yeah, the bar owner, they called last call for alcohol, and that's when we decided to go.
But you, Miss Levin, decided to order an Uber, didn't you? Is that a yes or no question?
I didn't feel safe getting in the car with Jess, so yes.
And Miss Mark, you offered that Uber to Miss Marks, didn't you?
Yeah, I wanted her to get in with me, but she didn't.
You refused, didn't she?
She started goofing around in the parking lot. But yeah, she didn't get in with me.
In fact, Miss Levin, she said, I've gotten pretty good at driving after a big night.
Objection, Your Honor. Improper character evidence. May I be heard, Your Honor?
You may be heard.
Your Honor, this is improper character evidence, seeing that opposing counsel is attempting to insinuate that Jessica Marks has driven under the influence of alcohol many times before, leading her to do the same thing in today's case.
And your response, counsel?
Yes, Your Honor, we're not offering this for a character purpose. We're offering this to show that Ms. Marks had an intent to drink and drive that night.
If I may be heard, Your Honor.
Yes, you may.
Your Honor, if this is what opposing counsel is attempting to bring out this evidence for, then they are attempting to pursue a specific character trait, whether that's of irresponsibility or the fact that Jessica Marks had a habit of driving while drunk. That would be improper character evidence today.
All right. Well, given that the issue of the case is the conduct of the bar, I'm inclined to sustain the objection on grounds of relevance, but I'm going to give you a chance to respond to my comment.
Yes, Your Honor. While the cause of action the plaintiff has brought has to do with the bar, the defense has also brought an affirmative defense, which argues that it was Ms. Marks's negligence that led to her death. Therefore, it's relevant because it shows Ms. Marks chose to drink and drive.
All right. Well, I did not really study this particular issue, but I think that the affirmative defense is superfluous. Because I think it's almost assumed that the decedent was negligent. Otherwise, she wouldn't be drunk and driving. So I'm going to sustain the objection on that basis. But I'm not going to preclude you from offering your affirmative defense generally. But I'm going to sustain.
Yes, Your Honor.
That objection.
Ms. Levin, you then watched Ms. Marks walk over to her car, didn't you?
Yes.
You saw her start it.
Yeah, she got in her car while I got in my Uber.
And you saw her drive away.
Yeah. And she only made it, 2 minutes before she crashed.
Thank you, Ms. Levin. Nothing further at this time.
Redirect?
None at this time, Your Honor.
All right. Ms. Levin, you're excused. Thank you very much.
Thank you.
And Your Honor, my apologies, Your Honor. Your Honor, right before the plaintiff begins to rest our case, there is a few things we would like to bring to your attention.
Is there evidence, documentary evidence you plan to admit?
Well, Your Honor, we would like to bring up evidence that has been pre-admitted as we established in pretrial today.
All right. Go ahead.
Now, Your Honor, if my second chair may, I would like to display an exhibit for the court. You see, Your Honor, under the stipulations, as we could see under stipulation 11, exhibits 1, 22, and 23 are pre-admitted, and they may be used at any time in the trial. So with that being said, I'd like to begin by showing the court exhibit 22.
All right.
And Your Honor, I would like to let the record reflect that I'll be making an on-record reading of the last part of exhibit 22.
All right.
Your Honor, this says, under toxicology, blood drawn at the scene of the accident contains 0.16 grams per 100 milliliters of blood. Blood drawn on March 25th, 2019 at 2 a.m. contains 0.12 BAC. Your Honor, after that, I'd like to make an on-record reading of exhibit 23. This is the police report done by Officer Gaskins. In this report, in the second to last paragraph, it states, based on all of this, I determined to a reasonable degree of professional certainty that the case of this accident was driving under the influence of alcohol. And with that, Your Honor, the plaintiff rests.
All right. Whenever you're ready to proceed with your case in chief, go ahead.
Yes, Your Honor. At this time, the defense calls Sunny Mehta. Good morning, Ms. Mehta.
Good morning.
Where are you from?
I'm originally from a place in Queensland, Australia called Ghana's. It's a small portion of Mission Beach, but right now I'm living in California.
What do you do for a living?
Well, I consider myself to be an entrepreneur. I used to own a bar, but I'm looking into new ventures now.
What was your bar called?
It was called Sunny's Rooftop Bar, and it was open since 2017, but we had to close down recently.
What did you used to serve there?
Well, typical things that you would find at any restaurant or bar. We had some small appetizers, but mainly alcohol.
I'd like to talk about some of the features of your bar. Where do most of the guests sit?
Well, at Sunny's Rooftop Bar, our rooftop was pretty much the main event, the main attraction. It had a gorgeous view, so a lot of our customers would sit up there since our bar seating on the inside only had about 10 chairs.
Do you have a bar on the roof?
No, we don't have a bar on the roof. It's pretty easy to run drinks up and down the stairs, so we just do that instead.
So where is the bar located exactly?
It's on the first floor, the main floor, right when you walk in.
All right, I'd like to talk a bit about your training as a bar owner. What training do you have?
Well, the state of California mandates that bar owners have to train their employees, and we also have to take the responsible beverage service course and pass a final exam to ensure that we're well versed in the manners of identifying intoxicated people, ensuring that we're not serving minors, that sort of thing.
Do you ever have to update that training?
Sure, so every 3 years you have to retake the exam to ensure that you're still up to date with all of the information that you need.
All right, I'd like to talk now about March 24th, 2019. What were you doing that day?
Well, I was working at my bar that night. It was just myself and Frankfurt Johnson. Since it was a Sunday evening, we didn't really expect a huge crowd to be coming in.
How many people were at the bar?
Well, inside there were a few guests, but there were maybe 20 people total on the rooftop over the course of the night. There were never more than 12 to 14 at one point, though.
I'd like to talk about one of those guests. Did you ever see a woman named Jessica Marks?
Yes, I did. She came in with her friend, I believe her name is Morgan Levin, at around 9 p.m. that evening.
Had you ever seen her in your bar before?
No, they were both new customers.
Where did they sit?
When they came in, they immediately went up to the rooftop and they sat at table 4.
How many times, or how did Miss Marks appear when she entered the bar?
Oh, she seemed totally fine, completely sober.
How many times did you see her over the course of the night?
I took their orders maybe 4 to 5 times, and I served them drinks 4 to 5 times as well. So I would say maybe 8 to 10 times at the most.
How long were those interactions?
I'd say around 30 seconds, never more than a minute total.
Did you ever see the two inside at your bar?
Well, the only times that they were inside the actual bar, not on the rooftop, were when they first came in, and obviously they went directly to the roof from there. And when they were leaving, they had to exit through the front door.
And Miss Mehta, did you ever see Miss Marks stumble coming inside?
No, not once.
Do you remember seeing any signs of Miss Marks's intoxication as the night progressed?
No, I didn't think that she seemed intoxicated at all. I mean, throughout the course of the night, she may have been a bit loud at one point, but I think everyone was on the roof. We had some music blasting pretty loud that night.
Have you ever cut a customer off before?
Oh, plenty of times. In fact, it's pretty regular practice. If we see people who are obviously intoxicated, of course, we want them to be safe. So we'll cut them off, say something like, I don't think we should serve this person anymore, or just stop serving them drinks entirely.
Did you cut Miss Marks off?
No, I had no reason to. She wasn't acting obviously intoxicated any of the times that I saw her.
All right, I'd like to talk about another one of your bar patrons, Stevie Rieger. For the record, I am screen sharing what has been marked as Exhibit 23, Stevie Rieger's testimony, and I will be reading in sections for the court. Question, we're here to talk about an incident that occurred on March 4th.
All right, just want to clear, I just want to make sure there's no objection from plaintiff's counsel.
Yes, Your Honor, I would object. As to facts not in evidence, this exhibit was never entered into evidence yet.
And your response, counsel.
Your Honor, I can offer that exhibit in now.
All right, well, can you give me a little more background as to what this is?
Yes, Your Honor, it's the deposition of Stevie Rieger, a bar patron that night. It was made under oath and And
is it established that he was unavailable to testify at trial?
Yes, Your Honor, he is not able to testify today.
All
I
right,
believe there's a stipulation about it.
all right, then let's treat it as court testimony. And then the question is there any objection to the question and answer on any other evidentiary grounds?
Not at this moment, Your Honor.
All right, in that case, we'll continue reading, please.
Question, we're here to talk about an incident that occurred on March 24th, 2019. Where were you around 9 p.m. that night? Answer, Sonny's watching the end of the Lakers Kings game. Question, would you say Jessica was visibly intoxicated? Answer, visibly intoxicated? I mean, she wasn't fall down drunk, but she didn't seem perfectly sober either. Question, did you ever see Jessica stand up? Answer, probably. She was there a couple hours, but I didn't see her fall or stumble, if that's what you're getting at. Now, Ms. Mehta, I'd like to ask you, are the statements that Stevie Rieger makes in his testimony consistent with what you saw that night?
Yeah, everything that was said in there about her not stumbling, her seeming maybe a bit buzzed, but definitely not intoxicated, that's all what I saw that night.
Thank you. Finally, I'd like to talk about the end of the night. When did you last see Miss Marks and Miss Levin?
Well, they came down from the roof at about 11:45, and I believe that Miss Levin was paying the tab, signing everything off so that they could leave.
How did Miss Marks appear to you then?
Totally fine. I mean, she was able to walk straight. She held a conversation at some points. She didn't seem intoxicated.
Have you ever called an Uber or a taxi for someone you think's obviously intoxicated?
Oh, plenty of times. Like I said before, I would never want any of my patrons to get hurt because of anything that I've served them. And so I would often call an Uber, a taxi, a cab, whatever their preference was, to make sure that they got home safely that night.
Objection, Your Honor. As to character evidence, may I be heard?
You may.
Your Honor, Sonny Mehta just testified that normally when a client seems intoxicated or drunk or tipsy, they'll call them an Uber and make sure they get home safe as part of their character. This is inadmissible because they're using this to prove that on the night in question, they didn't do this according to that character trait. Therefore, this is inadmissible today.
And your response?
Yes, Your Honor. This falls under the character evidence exception, routine or habit or routine practice. Since it is Sonny's Rooftop Bar's routine practice to call cabs for people who are obviously intoxicated, and this testimony shows that they acted in accordance with that routine practice on the night of March 24th, 2019.
All right.
If I may be heard.
Just let me make sure I understood what's going on here. My impression was the objection was that the testimony was being used to impugn the decedent's character. Is that right?
No, Your Honor. The testimony that was given in court was Sonny Mehta saying that normally when a client is intoxicated, they'll call them an Uber, and they're attempting to insinuate that on the night in question, they didn't do this because the client was not intoxicated. Therefore, this would be character evidence, and it wouldn't fall under the exception that opposing counsel has offered, seeing that this is Sonny Mehta's own character and not a practice of her bar itself. This was simply that Sonny Mehta took upon herself.
All right. Well, I'm not sure I fully understand what's going on here, but I do know that I am not going to sustain the objection, so I'm going to allow the testimony.
Miss Meta, have you ever called a cab or an Uber for someone who's obviously intoxicated?
Of course, plenty of times. Like I said, we don't ever want someone to get hurt or injured or something to happen to them because of what happened inside our bar. So if I notice a patron who is obviously intoxicated, I'll call them an Uber or a cab or a taxi, whatever their preference is, and make sure that they get home safely.
Did you do that for Miss Marks?
No, because I had no reason to. Miss Marks was not obviously intoxicated. She wasn't in a position where I believed that she needed someone to help her.
Objection, Your Honor, as to lack of personal knowledge, if I may be heard.
You may.
Your Honor, this witness just stated that Jessica Marks was not intoxicated. This would be a lack of their own personal knowledge because they weren't Jessica Marks, and this witness is not a toxicologist. Therefore, if they aren't saying that they think she wasn't intoxicated, this is inadmissible.
All right, I didn't hear it that way, but I'll instruct the jury that she's not an expert and that she's not giving any opinions, and that all she was saying was that it appeared to her that the person was intoxicated, and she is qualified to give that lay opinion. All right.
Yes, Your Honor.
So Miss Meta, why didn't you call an Uber or taxi for Miss Marks?
There was no reason for me to. She, in my personal opinion, did not seem obviously intoxicated. She didn't have any of those indicators of an obviously intoxicated person that I've been taught to look for.
Thank you, Miss Meta. Nothing further at this time.
All right, cross-examination.
Yes, Your Honor. Good afternoon, Ms. Meadow. Now, I'd like to start off by discussing the history of Sunny's Rooftop Bar, which you no longer own. In Sunny's Bar's early stages, the establishment had gotten a couple citations for serving underage guests, correct?
Sure, there was one instance in 2018.
And in that instance, an underage man was injured after he just drank at your bar, correct?
He had tripped, I believe, falling down some stairs or stumbled, and so he was injured.
And in order to make amends, you offered this underage man free drinks for an entire summer, correct?
Well, to be clear, we offered to pay for all of his damages, anything that happened to him. And yeah, we offered him free margaritas, virgin, of course.
Now let's just talk about your bar's interactions with Jessica Marks on March 24th. Was Jessica Marks ID'd that day?
Well, it's standard practice in my bar to ID all customers who look under the age of 45. So, of course, I'm sure she was.
So after she was ID'd, she was allowed to drink, correct?
Yeah, that's the regular process of how everything happens in my bar. We check the ID, we ensure that they're of age, and then they're allowed to order drinks as they please.
But you know today that Jessica Marks wasn't of age, correct?
Well, unfortunately, I do know that now.
Now, if the ID that Jessica Marks presented to you with on March 24th was shown to you right now, would you recognize it?
I'm not sure necessarily if I would recognize the exact ID that I was shown. When I was deposed, I was shown a couple of obviously fake IDs.
Thank you. Now, Your Honor, at this time, my second chair will be displaying Exhibit 3 for the court. Do you recognize the individual in this picture?
I do recognize the person in the picture. That's Jessica Marks.
Your Honor, at this time, I would like to move to enter Exhibit 3 into evidence.
Any objection?
Yes, Your Honor. I object relevance. It's already been established that Miss Marks was underage, so I don't see how a fake ID is relevant to today's charges.
If I may respond to that, Your Honor.
You don't need to. Overruled.
Now, Ms. Mehta, is this ID real or fake?
This is clearly a fake identification card. I mean, you can see it doesn't have any foils. There's no height or weight or ethnicity indications. It's a fake ID.
So, Ms. Mehta, in under just 2 seconds, you told me this ID was fake. Did you do the same when Jessica Marks handed it to you on March 24th?
Well, No, I don't specifically remember checking this ID and seeing it was fake on March 24th, but I'm sure that Miss Marks did hand me an ID that I checked.
Now, Miss Meta, let's move on to what happened later that night. And during that night, you made an estimate of 8 to 10 stops to Morgan and Jessica's table, correct?
Yes, I was very busy that night serving some of the other customers on the rooftop, running drinks up and down, doing sort of waiter things, making sure that tables were cleared. So I only saw them around 8 to 10 times that night.
And you just testified previously on stand that you were able to observe her actions and behaviors, right?
Well, I was able to pretty casually observe from the 30-second to 1-minute interactions that we had over the course of that night. And through those interactions, I didn't notice any signs of obvious intoxication.
Now, Miss Meta, let's look a little deeper into that. You were present today for the playing of Exhibit 10 in court, right?
I don't necessarily believe I was. I've been sequestered.
Well, Your Honor, at this time, just outside of the earshot of the jury, I would again like to bring to the court's attention that Sunny Meta was not sequestered in this trial, seeing that they are the party representative.
Okay, well, either she was or she wasn't. If she's as a party representative, she certainly had the right to be present during the trial. But since she was not a criminal defendant in handcuffs, she didn't have to be. So I think we're going to have to go with the she chose not to be here route. And you're free to comment on that in your closing if you want.
Yes, Your Honor. Now, at this time, I would like to present Exhibit 10 for the court once again. Now, since this video was already played, I'll simply play the first 10 seconds of this video for the court.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive.
Thank you, Second Chair. You can now pause the video.
And everyone here looks to be.
Now, Miss Meta, in this video, you can hear Jessica saying that she was at a bar in Hollywood, correct?
Yes, I believe that's what she said.
Isn't your bar in Malibu?
Well, yeah, it's in Malibu, but we get a lot of people that are from outside of town that may say something like that. They don't necessarily know all the specific parts of California.
So that could be a possible confusion or not making sense, correct?
No, not at all. I mean, it is a pretty big area and there are different parts, different intricacies. And to be fair, I think she was only there for about a week.
Thank you. Now, Miss Meta, I'd just like to get a little bit into how you know of how alcohol affects BAC and the blood. You went through training to understand this, didn't you?
Yes, I had to take the responsible beverage service course, which teaches us signs and factors to look for to see if someone's obviously intoxicated.
And managers and servers at bars across the state of California need to obtain an alcohol server's certification from this course, correct?
Of course.
And part of this training consists of learning how BAC affects a person and how alcohol affects BAC, right?
Yes, to some degree.
Now, you served Jessica Marks that day, didn't you?
I did.
And you served multiple drinks to her table, didn't you?
I did. Like I said, I visited around 4 to 5 times to actually serve the drinks themselves.
And although you didn't witness her drink any of those drinks, you stated in your deposition that you didn't remember her not finishing them, correct?
I don't explicitly remember whether or not the bottles or cans that I took back were full, empty, half full, or anything like the sort, no.
And Miss Meta, therefore, if Jessica Marks drank even less than half of these drinks, her BAC would be affected, wouldn't it?
Well, of course, if you consume alcohol, your BAC is going to be affected to some degree.
And if she drank even less than half of it, her BAC would likely be well over the withhold of the limit, correct?
Objection, Your Honor. This calls for speculation.
If I may be heard, Your Honor.
You may.
Your Honor, this witness just stated yes when I asked if when they underwent training, they were informed of how alcohol affects BAC. Therefore, they wouldn't be speculating. They would be recalling past knowledge that they were taught in the training course.
Your Honor may be heard.
You may.
Counsel is asking a far more specific question, whether or not Ms. Marks's BAC would be higher than the legal limit, which is 0.18, a very specific number. Ms. Mehta does not have the specific knowledge to know how many drinks would result in a particular blood alcohol content.
Okay, well, she runs a bar or did run a bar, so I think she would. So I'm going to overrule that objection.
Yes, Your Honor.
You could answer the question, Ms. Mehta.
In regards to actual BAC level, I'm sure that there are a certain number of drinks that will specifically push someone past that legal limit. But in terms of obvious intoxication, it really varies from customer to customer.
Now, Ms. Mehta, you would agree with me when I say that if someone drinks alcohol, they're under the influence of alcohol, correct?
Well, being under the influence is a kind of technical term. Under the influence kind of insinuates that someone is not in control of themselves. And so I'm sure that there are some people, I've observed it myself, that after one glass of wine are still under the influence of their own impressions. They can still control themselves. And so it varies from person to person.
But that would mean that they have alcohol in their system if they're under the influence, yes or no?
If someone is under the influence of alcohol, they would have alcohol in their system.
And Jessica Marks had
Your
alcohol
Honor,
in
I
her
believe
system.
that counsel is out of time.
Okay, will the timekeeper confirm that to me? Because I'm not paying attention.
Yes, Your Honor.
All
He
right,
is out of time.
thank you very much. Any redirect?
No redirect, Your Honor. May Ms. Mehta please be excused?
Yes, you're excused. Thank you.
And Your Honor, at this time, the defense rests.
All right. Are we ready for closing statements from the plaintiff?
Yes, Your Honor, but first we would request if we could have a brief recess before closing statements.
Okay, well, I'm not supposed to give recesses, and I'm late, but I'm going to give you 3 minutes.
Thank you, Your Honor.
All right, so I show 10:10, so let's be back at 10:13. Statements.
May I begin, Your Honor?
Whenever you're ready.
Members of the jury, you just finished hearing the tragic story of Jessica Marks. The tragic story of how a 19-year-old girl was neglected by a bar who only saw her as a stack of cash. And she was only a stack of cash when they served her drink after drink after drink, pushing her closer and closer and closer to her death. And this all happened because the defendant served, they observed, and they looked the other way. They couldn't care less. Members of the jury, the defendant was wrong. What the defendant did defied morals, basic reason, and it defied the law. You see, under the California Dram Shop Act, if a bar overserves a customer that they observe to be obviously intoxicated, it's their duty to cease service to that individual. It's not their choice, it's their duty. Meaning that if a bar refuses to do this, then by law, they're liable in a civil proceeding. What happened on March 24th was a violation of this exact law. So let's look at what happened based off the facts that you heard today. And you heard Morgan Levin testify. And Sonny Mehta chose to not be here for Morgan Levin's testimony. Sonny Mehta chose not to be here when Morgan Levin was testifying to how the defendant drove her friend to their death. Who would want to be here for that? But you heard all of it. You heard Morgan Levin tell you that Jessica Marks walked in to Sonny's rooftop bar and drank. She didn't just drink, but she was served after she was observed. And then right after that, the defendant, they looked the other way. They were served 5 times that night. And in fact, the bar owner made 10 stops to their table that night. So 10 times, Sonny Mehta looked 5 foot, 110 110-pound Jessica Marks to her bloodshot eyes and poured another drink. She couldn't care less. 3 White Claws and 6 glasses of wine, a shot, and a pint of beer. Jessica drank all this and she wasn't obviously intoxicated. A 19-year-old, 5 foot, 110-pound girl drank all of this and she wasn't intoxicated. An autopsy found 0.16 BAC in that young girl's body and she wasn't intoxicated. Now, it may sound absolutely absurd right now coming from me. But that's the case that the defense presented to you today. Miss Mehta, she took the stand and she told you that her bar has served underage individuals before. They've gotten citations for it before. And in a time in 2018, when the same thing happened and the underage minor was injured, they paid for their bills and then went and offered free drinks. Free drinks for an entire 3-month summer. Members of the jury, not only did they do this in 2018, on March 24th, 2019, they served Jessica Marks. They served her 12 drinks. And they still say she wasn't intoxicated. But if the human brain develops at 25 years of age, Jessica Marks was 19, 5 foot, and 110 pounds. Was she really not intoxicated by 12 drinks? She got so intoxicated, she tripped down flights of stairs. The bar owner questioned if she was fit to drive home and if she needed to be cut off. And Sunny Mehta couldn't deny a single fact out of all this today for you. Members of the jury, today we proved our case, and we proved it through a preponderance of the evidence because we had the burden of proof today. The defense brought up what is called an affirmative defense of comparative negligence, but they couldn't push that onto you because it doesn't hold its weight. We did our job today, members of the jury. We delivered the facts of this case, and since the defense refused to deliver you the truth, we did that as our job. We showed you that the defendant served, they observed, and they looked the other way. Because of that, Sunny's Rooftop Bar deserves to be held liable, because we won't let them look the other way again. Thank you.
All right, closing statement from the plaintiff, defense.
Yes, Your Honor. Don't drink and drive. We learn this fundamental rule before we're ever allowed behind the wheel of a car. We see those signs on bridges and highways that memorialize the victims of drunk driving. Don't drink and drive. We hear stories about relatives, friends who are killed in drunk driving incidents. Jessica Marks is no different. She was a young girl, a teenager who passed in the prime of her life because she decided to drink and drive. Now, before getting more into the facts we heard today, let's talk about that burden of proof. Because today, Mr. Wittere claimed that Jessica Marks was intoxicated. He showed her blood alcohol content, but that's not what the law requires. To hold Sunny's Rooftop Bar liable, Mr. Wittere had to prove that Jessica Marks was obviously intoxicated when served drinks. And also that Sunny's Rooftop Bar serving that alcohol was a substantial factor in her car accident. But Mr. Wittere has failed in that burden. In addition to addressing that cause of action, you heard me in my opening lay out an affirmative defense, which argues that Jessica Marks is the one at fault for her accident. Now, we recognize it is incredibly difficult to blame a 19-year-old for her own death, but that's not what we're asking you to do. This case isn't about blame. It's about the evidence. And the evidence points towards Jessica Marks's decision to drink and drive, causing her car accident. So let's talk about that first element, obvious intoxication. Because obvious intoxication is what a reasonable person would perceive to be drunk. We heard Morgan Levin's account of that night, that Jessica Marks was obviously, clearly, visibly intoxicated. But members of the jury, we also heard that Morgan Levin was threatened with a lawsuit by the plaintiff. That Morgan Levin then turned witness for the plaintiff. Is Morgan Levin's testimony credible? But even beyond that, we heard from Sunny Mehta that Sunny Mehta was working that night. She was taking orders, delivering drinks, clearing tables. She was going from the bar underneath to the rooftop above every single time someone ordered a drink. So what Morgan Levin saw that night, a friend of 6 years who was sitting with Jessica, watching Jessica, is different from what Sunny Mehta saw, who was working, who was moving, who had interacted with Ms. Marks in 30-second to a minute-long intervals. That's not enough to constitute obvious intoxication. It's not enough for the plaintiff to meet their burden. But even in addition to what we heard from Ms. Mehta and Ms. Levin, we heard the testimony of a bar patron, Stevie Rieger, who testified Jessica Marks was not obviously intoxicated. We heard maybe she wasn't perfectly sober, which matches with the symptoms Ms. Mehta gave, that she was a bit loud. But is that really out of the ordinary for a young girl at a bar? No, it's not. So let's move into the affirmative defense. Because in his opening, Mr. Wittere said, the time is past to ponder Ms. Marks's actions. That simply is not true. We're here to determine liability for this car accident. And so, as under the defense's affirmative defense, Ms. Marks's actions matter. And we heard members of the jury that Ms. Marks came to LA with 2 fake IDs, one for herself and one for her friend. She visited 8 bars and restaurants before ever even stepping foot in Sunny's. We heard she drove to and from those bars and restaurants. And we heard on the day of March 24th, 2019, that Ms. Marks consumed alcohol at her Airbnb. We even saw that image, those 2 empty wine bottles that Ms. Marks consumed, either the week before or perhaps even that day. We heard that she decided to drive to Sunny's anyway, that she decided to order drinks at Sunny's anyway, that she decided to leave Sunny's, that she decided to refuse her friend's offer for an Uber, that she decided to walk over to her car, to put her key in the ignition, to start it, and to drive away. These were Jessica Marks's choices. And they prove a sad reminder. Don't drink and drive. In a case like this, we want answers. We want to know why a young girl of 19 died. We want someone to blame. But in this case, there's no one to blame. There's only those words, don't drink and drive. Please find Sunny's Rooftop Bar not liable for Jessica Marks's car accident. Thank you.
I'm working on the assumption that if you have time left, you're allowed rebuttal.
Yes, Your Honor. I would just like to ask my second chair how much time I have left for rebuttal.
I would like to clarify that the prosecution has 2 minutes and 30 seconds left for rebuttal.
All right. And am I also right in thinking that the defense doesn't get sir rebuttal in this competition?
Correct,
Yes,
Your
No
Honor.
rebuttal for the defense.
All right. Thanks very much. Go ahead whenever you're ready.
Thank you, Your Honor. Members of the jury, Miss Morris-Beber just got up here and told you these words. Don't drink and drive. We learned it since we were little. We've heard stories about drinking and driving. We see it on billboards. We see it on the news. Don't drink and drive. Except what she doesn't realize is that the words she just told you contradicts what she's been saying throughout this entire case. If drinking and driving is so bad, then why did Sonny Mehta let Jessica Marks drive? He served 11 drinks and he let her drive. Now, please look at the screen as my second chair shares an exhibit for you members of the jury. Now, Jessica Marks drank all of this. Please watch. Jessica Marks drank all of this, and Sonny's rooftop bar let her drive. And members of the jury, what makes this even better is that in Miss Morris-Beber's closing statement, she just told you that there's no one to blame. She told you word for word that there is no one to blame. It's her affirmative defense of comparative negligence to tell you that there is someone to blame. That is Jessica Marks. But according to her, there isn't, because she said there's no one to blame. It was our job today to prove to you that Jessica Marks was a minor, and we did. To prove that Jessica Marks was served alcohol, and we did. We had to prove that Jessica Marks' death was a proximate and foreseeable cause of the drinks that the defendant served that night, and we did. Because of this, we ask you to remember these final words as you deliver your verdict. Deliver a verdict in favor of the plaintiff. Thank you.
Very good. That concludes the trial. Fortunately, under the rules of this competition, I don't have to pronounce a verdict, unlike California high school.